Thank you everyone for coming to this final session of the 2020 Indiana Leeds Summer Tax Workshop Series. I'm Leandra Lederman. I'm the William W. Oliver Professor of Tax Law at Indiana University Maurer School of Law in the United States, and I'm co-hosting. And now I'll turn it over to my co-host to introduce himself and our speaker.
Thank you, Leandra. I'm Dr. Leopoldo Parada. I'm a lecturer in tax law at the University of Leeds in the United Kingdom. And I'm very glad to have arrived to this last session of the workshop series with a fantastic also speaker and a great topic. Today, we have the pleasure of having Dr. Monica Victor. Dr. Victor is an SJD in taxation from the University of Florida. She also holds a Master of Advanced Studies in International Economic Organizations from the University of Zurich and a Master in International Law and Economic Integration from the State University of Rio de Janeiro. Formerly, she was a tax attorney for the Ministry of Finance in Brazil during almost 27 years, and also a senior tax researcher in the South Center in Geneva. Today, Monica is presenting the Taxman's Guide to the Galaxy, Allocating Taxing Rights in the Space Economy. A very fascinating topic, brand new topic. So Monica, thank you so much for being with us. And now the floor is entirely yours.
Good morning, everyone. I'm really happy to join you this afternoon because today I will present my paper that is a mix of two passions of mine, taxes and space and astronomy. I used to be a member of the astronomy club while in high school, member of the Alashua Astronomy Club while I was in Gainesville for my SJD. So it's a topic that from time from time I revisit, I get updated. So I'm very glad to be here to present for you my last paper, the Taxman Guide to the Galaxy. The presentation will work as follows. Here's the roadmap. First, I'll give you some figures about space economy business. Then I will describe the space law treaties and to further explain the current state of affairs at the international taxation level, describe the OECD, UN, and US space taxation provisions. And I will finish my presentation speaking about the challenges of the space economy taxation. Well, the space economy, it's not sci-fi anymore. It's a 400 billion business industry, and the commercial use and exploration of outer space by private parties are even outpacing official investments, the official governmental participation. However, we don't count with a clear assessment of the risks associated with the use and the exploration of outer space and other celestial bodies. For example, you don't have a protocol to follow in the case of alien species invasion, environmental damage, either on Earth or other celestial bodies. We are not discussing import quotas for outer space natural resources. You know, we should discuss that because we cannot bring unlimited natural resource from space to Earth because mass is a crucial factor in all astrophysics formulas, for example, to calculate orbit, celestial body speed, or gravity. Although we don't have still this risk assessment, we don't know all the risks associated with the commercial use and exploration of outer space, we already have a body of international legal agreements, binding international legal agreements that were negotiated during the 60s by the time of the Cold War. The most relevant instrument is the Outer Space Treaty that counts with 110 ratifications, including the US, Russia, and emerging economies like India and Brazil. The Outer Space Treaty provides for principles and rules that should be a guidance for the regulation of all aspects related to the use and exploration of outer space. For example, we have the province of all mankind principle, we have the no appropriation principle. Another special feature of the system is the rules about states' international responsibility and liability. You have specific rules that are linked to the launched state activities. They are deemed, they will bear the responsibility of damages from space objects that are launched from their facilities. And we have common and shared responsibilities. For example, the rescue of astronauts. That's the responsibility of the states in which the territory, the accident occurs. And for me, the most interesting provision from those agreements are the mandate to seek for a balance between the interests and needs of developing countries and the state's contribution to the use of space. In other terms, the system must seek a balance between development goals and the investment protection. Recently, the White House has approved an executive order that mandates the US Department of State with the Artemis project and Accords. The Artemis project was supposed to, the US Department of State is supposed to draft a multilateral agreement, a multilateral binding agreement on the commercial use and exploration of outer space and celestial bodies by private parties, and provide for bilateral accords between countries that share the same views of the US, the same US views. However, all this bundle of international agreements do not provide the most basic answer. Where is outer space? That's not answered by any international law, space law agreement. And that reflects the current state of affairs of the international taxation legal system. Because we don't have a clear boundary between outer space and space air, for example, both the OECD model and the UN model provide just few guidance, and all related to the taxation of satellite services, of income derived from satellite services. For example, for the OECD, satellites and satellites footprints are not considered as permanent establishment. Under the UN umbrella, income derived from contracts to supply satellite-based services can be considered as characterized as royalty income and attract even the application of Article 7 or Article 12A from the model. So let's see what are what are the consequences of this field guidance at the international taxation, at the international level? I wrote about this example, the first example in my paper. I collect information that Tom Cruise was negotiating shooting and stream a move from the International Space Station. So in this case, let's see the first illustration. If he shot and streamed in a worldwide basis from the International Space Station, would that attract the application of Article 17 of the OECD model? No. And the answer is easy, because here the next rule is the place of performance. And in this case, the performance happened in the International Space Station, which is territory of no state. So the only tax authority that could exercise taxing rights would be the residence tax authority. The second example, moon mining activities. In this case, you cannot apply the international taxation treaties, because you don't have a territory of another contracting states where the activities are carried on. Again, you only have the residence state capability to tax income derived from moon mining activities. And what are the issues about those limitations of the international taxation system? First, you're rendering moot the province of all mankind principle. Yet, states would incur expenses in the case of damages attributable to the use of exploration of outer space without matching tax revenue. And we cannot price negative externalities that are associated with use and exploration of space. This lack of guidance at the international level has prompted the approval of domestic rules. And probably the first country that had approved specific rules regarding the taxation of space economy was the US. In the US tax reform of 1986, the Congress has approved the inclusion of Section 863D to the US Taxation Code. According to this provision, income derived from a US first from the exploration of outer space would be sourced within the US. And income accrued for foreign persons would not be sourced within the US unless this person incurs in trade or business within the US. Another interesting features are the carve-outs. International telecommunication services, international transportation services, and mining activities are not regulated by this section. So the most promising industries, space economy industries, are not covered by the Section 863D. At the state level, we have the granting of tax incentives for the sectors, for example, by Florida and Virginia. And we have a failed attempt to impose tax on space economy activities by the state of California. What are the challenges that the international taxation system would face while negotiating and debating the rules for the space economy taxation? First, differently from the digital economy, international taxation bodies would have to cooperate with well-established international space bodies such as the UNOSA, the United Nations Office for Outer Space Affairs, among others. We have regional bodies as well. Second, the international taxation system would have to reconcile with the rules and principles of the international space legal system, because those are binding rules. Those are international agreements and commitments with a broad acceptance. 110 countries had ratified the Outer Space Agreement. And second, the international taxation system would have to seek taxing rights, next rules that would be appropriate for the space economy. The current negotiations are about proper tax rules for brick and mortars and the digital economy, but not for the space economy. Let's see now what are the proposals that we have to deal with the tax challenges of the space economy. We have the proposal to create an international fund, a universal tax regime, and my proposal that is negotiating allocation rules. That's my understanding that the establishment of international fund or a universal tax regime would imply the creation of international tax authority, international bureaucracy, which is very expensive, would face the same challenges of official development assistance. We would have to be careful about moral hazard issues and equals. And as I can illustrate with the picture in this slide, space companies are already setting and conduct activities in developing countries. All those companies in the Africa map has been incorporated in Africa and are carrying out commercial activities in Africa, in developing countries. So that's my understanding that allocating tax rights would be a more efficient approach to deal with those challenges. But we have other reasons to advocate for the allocation of taxing rights. For example, an international fund could not deal with stateless income problem, could not address residence as the only next rules for allocating tax rights. That would imply in the flag of convenience issues that had haunted the international sea regime as well. So what's my proposal? The first task, the first matter in my proposal is that I advocate for a close cooperation between the international taxation organizations and international space law organizations, such as the UNOSA. I think we cannot, their expertise cannot be neglected. They have been working on the issues for more than half century, so a close cooperation would benefit the international taxation system. And as nexus rules for allocating tax rights in space economy, I would propose two rules. First, the most obvious one, which is allocating tax rights for launching states. And the second one, to reconcile both systems, would be an apportionment that would reflect the balance between the interests and needs of developing countries and the state's contribution to the use of outer space. I think that would be very important. And why this is important? Why I took my time to write this paper? Because I think we should not make the same mistakes from the past and from the present relating to the negotiations of tax rules, of taxing rules. And that's not a shaming slide. The ones who are familiar with my previous papers know that I'm completely against shaming, the use of coercive diplomacy to address tax issues. What I would like to show in this e-slide is that what we call harmful tax competition or aggressive tax planning could be rephrased as government inaction, lack of wish to cooperate, and those actors are just benefit from the loopholes that this inaction presents, the opportunities presented by those loopholes. And when dealing with the space economy, that's really urgent and relevant because we are dealing with the unknown. We don't know the risks associated with this quest for the universe, for interplanetary species or natural resource located at outer space. So we cannot be late in this discussion. It's not like the digital economy that it's a man's creation, a man-driven sector that we could have some control. Here, we don't have control. We don't have all the scientific questions answered, all the risks assessed, so we must hurry on the debate. And I would like to finish my presentation with an invitation for the audience to go stargazing for some moments and make some reflections. We could benefit from the current meteor shower in the skies that are happening now. And I'm sorry to tell you, but maybe I will have spoiled your stargazing adventure, because now I'm sure that you're gonna think about the tax consequence of stargazing and exploring the universe. So thank you very much for your attention. I'd like also to thank Leandra, Professor Lederman and Professor Parada for this initiative and for the opportunity. Thank you very much for your attention.